Good afternoon, folks, and welcome to this week's episode of the Legal Beagle podcast. We are back in the Legal Beagle library, yet to be sponsored. However, my mom contacted me after last week's podcast and asked when I put a library in my house. It's not a real, look at my hands continuing to disappear. It's not a real library, Mom, but if you want to sponsor the Legal Beagle Library, please reach out to me and let me know, and we can call it something else other than the Legal Beagle Library. But for now, we'll stick with that. So in this week's podcast, we're going to talk about the election. Just kidding. I don't think anyone wants to hear anything else about the election at this point. Every news outlet is covering every aspect down to every single vote that is being counted. So there's literally nothing that I can add to that. This week, we're actually going to talk about a legal theory called Res Ipsa Loquitur, which is Latin for the idea that the thing speaks for itself. What does that mean, right? What are you talking about, Jonathan? Let me unpack that for you. In order to understand why the concept of Res Ipsa Loquitur, let me spell that for you. It's Latin again. R-E-S, that's the first word. I-P-S-A, that's the second word. And then Loquitur, L-O-Q-U-I-T-U-R. If you look that up, most definitions will say the thing speaks for itself. But why would that ever come into play in your personal injury case? First, in order to get to Res Ipsa, we have to make sure we understand the concept of negligence. Negligence includes four things: duty, breach, causation, damages. Those are the four things you have to bring in an ordinary negligence claim. Duty means that people have a legal obligation to act as a reasonable person would, and that requires that they take reasonable care when they are out and about. So we'll put this in the context of an automobile accident. Duty is drive your vehicle safely. Breach of duty is you are not driving your vehicle safely. Maybe you are speeding. Maybe you are following someone too closely behind. Maybe you make a left turn on a red light. That is breaching that duty to operate reasonably and use reasonable care. Then you have causation, that breach of the duty caused injuries or damages to another person. And that's the fourth element, which are damages, which include property damage, your bodily damages, pain and suffering, all the things that would encompass that negligence claim. Well, what happens when you don't have such a clear line to the breaching party? There are two different types of evidence. There is circumstantial evidence and there is direct evidence. And I'll use an example that stuck with me from law school. So thank you, Professor Sanders. This is an example that I still think about today to explain the difference between direct evidence and circumstantial evidence. Let's say you wake up in the morning and everything is wet outside. Circumstantial evidence would be it rained last night, right? You actually didn't see it, but everything's wet, so it's safe to assume that it rained. Direct evidence would be you watch it rain and then see everything get wet. So you have direct knowledge of the event and can point to, it was raining last night. I saw it and then everything got wet. Different than circumstantial, where you see it in a situation where everything is already wet and you never saw it rain. Didn't hear it rain, but you can draw the inference that it rained. The reason it's important to understand the different types of evidence is because you can't always draw a direct line to the person that may have caused the harm. And I'll use an example again from law school. Big shout out again to Professor Sanders for these lessons. Let's say you're walking down the street and a flower pot from an apartment above falls off the ledge and hits you in the head. There's really no explainable reason why that would have happened. And let's go through the elements of negligence. So the person who owns that apartment where the flower pot was out on the ledge, they have a duty to operate in a reasonable manner. It doesn't mean they can't put a flower pot out on the ledge. Where's the breach? Where's the breach? Where did they fall below the standard of care? Well, probably in not securing that flower pot in a way that it couldn't fall down below and injure someone. And then if that flower pot does injure someone, that would be the cause of the damages that that person experienced. Res ipsa is a concept that in that flower pot example, the thing speaks for itself. A flower pot is not supposed to fall by itself down onto a sidewalk where people could be walking. It's foreseeable that people are walking on that sidewalk, traveling to and from different places, and a flower pot should not fall. So that thing, the flower pot that actually caused the damages, is really the reason that the person got harmed. But the homeowner or the person renting the apartment would ultimately be responsible for that, for not properly securing that flower pot and allowing it to cause the damage to the passerby below. So that's an example of res ipsa, where you don't actually have proper direct evidence, like the example in the automobile. You get hit by a vehicle and you can point to that vehicle and say, that vehicle hit me. You have circumstantial evidence where a flower pot falls down below and injures someone on a sidewalk. I want to use an example from one of my actual cases because I think maybe it'll resonate a little bit better and illustrate this point. I represented a gentleman who was at one of those big box retailers, and he went to buy something and he pulled this box off of the shelf, and it was above his head, so he had to reach up and pull it. As he pulled the box, he's tipping the box towards him so that he can secure it and then go purchase that product. When he does that, there's some debris on top of that box, and it falls off that box and into his mouth, and he ingests some of that debris. That debris included glass shards, and he swallowed that glass and then was immediately transported to the ER, where they had to pump his stomach and then monitor his stomach for potential issues with his intestines and just having to pass glass, not pass gas, pass glass, which can be very, very dangerous and can just rip up your intestines. So he was monitored. They were able to pull out any of the glass from his stomach before they actually entered his intestines. He was kept for monitoring for a few days and then released. And he was okay. But here's the point. We now have the task of trying to prove how that glass got there and why that big box retailer would be responsible for the glass falling into our client's mouth. That's the concept of res ipsa. I always just leave off the last word because it's just a mouthful to say Res Ipsa Loquitur. So I just say res ipsa. But that's the concept. The thing speaks for itself. That glass shouldn't have been there. It fell off of the box that our client was pulling down from a shelf to buy at this big box retailer, and then the damages incurred. The damages, not incurred, what's the word I want to use? The damages happened. We'll just use that word. The damages happened. So you have to have a theory about how that all that might have come into play. And our theory was that we went and looked at the area where this client was pulling down this box, and there were light bulbs above it. And we realized that what our assumption was, there was a possibility that light bulbs from time to time break. They from time to time go out, and the store has to change those on the display. And maybe an employee was up on a scissor jack or a ladder changing those and set them over there on the box for the purpose of just finishing what they were doing. And then they intended to come back and clean that up and maybe forgot and left the debris on top of that box, which eventually harmed our client. That is exactly the theory of res ipsa. So it's not always as simple as pointing to what we call the tortfeasor in our world, the person who acted badly. It's not always easy to point to the bad actor and say, "Oh, you hit me. You mopped that floor right there and left it wet without a wet floor sign. Your dog bit me. You have a product that's defective," right? You have to be able to prove that there was a breach. You have to be able to prove causation. You have to be able to prove your damages. But there are times where you don't have a direct line to proving those things. And that's where this concept of res ipsa can come into play, because you're essentially saying, it's certainly not the plaintiff's fault that this happened. We may not be able to point directly to the defendant, but we certainly can infer their responsibility and the breach of that standard of care, which caused the damages and injuries to the plaintiff. So I hope that's helpful. It's a simple way, or at least I felt it was a simple way of trying to unpack the concept of res ipsa. If you have any questions about that, if you have any thoughts on that, please give me a call. Please reach out to me by email. All of that can be found on our website, negrettilaw.com. Thank you guys. Until next week, take care. And hopefully we will have a decision on our president, or on who will be our next president come the next Legal Beagle podcast. Until then, take care.